Summary of a TCC Judgment 111 宪判18 2022 Case on the retroactivity of the provisions on the confiscation of proceeds of crime. Head notes. In this judgment, the Taiwan Constitutional Court (TCC) upheld the constitutionality of Article 2, Paragraph 2 of the Criminal Code. The said provision was amended in 2015 and shall apply to the confiscation of proceeds of crimes at the time of judgment, which provoked doubts on whether the amended text bear retroactive effects to crimes that happened before the promulgation of the amendment. The TCC ruled that since the disputed provision is a non-penal measure to rectify the unlawful property allocation caused by the crime, it does not violate the principle of non penal sine lege, the principle of lex retro non-agit, principle of non-retroactivity, and the principle of legitimate expectation enshrined in the Constitution. Background of the case. Before the enforcement of a new confiscation scheme, due to the insufficient regulation on confiscation of criminal proceeds in Article 38, Paragraph 1, Subparagraph 3, and Paragraph 3 of the Criminal Code 2014, and the restriction on the scope of it to the substantial objects acquired directly from the crime, set by the Judicial Yuan Letter Yuan 2140 of February 28, 1941, the offender and the mana fide third party may keep their proceeds of crime in the form of converted value or consideration if the pertaining civil responsibility were not pursued. The insufficiency in the aforementioned provision made it unable to deter crimes. Therefore, the legislators passed the new confiscation scheme through amendments on the Criminal Code in 2015 in pursuance of upholding the fairness and the inviolability of legitimate legal order, strengthening the people's trust in the rule of law, and ensuring the public interest of a society working according to the legitimate order. 7 petitions consist of 5 constitutional complaints lodged by persons. Based on their final court decision, 2 lodged by courts were lodged on this issue. The petitioner mostly argued that Article 2, Paragraph 2 of the Criminal Code made Chapter 5-1 of the Criminal Code, promulgated on December 30, 2015, entered into force on July 1, 2016, apply retroactively to the conduct happened before the law entered into force, therefore violate the principle of non penal sine lege, the principle of lex retro non-agit, principle of non-retroactivity, and the principle of legitimate expectation, consequently infringing the people's right to property protected by the Constitution. Summary of the judgment holding only the part ratio decidenti. The provision of Article 2, Paragraph 2 of the Criminal Code, hereinafter the said provision, for confiscation, the law enforced at the time of judgment shall apply. When applying the confiscation stipulated in Article 38-1, Paragraph 1 and 2 of the Criminal Code, is not in conflict with the principle of non penal sine lege, the principle of lex retro non-agit, principle of non-retroactivity, and the principle of legitimate expectation, therefore not in violation of the Constitution. First part of holding. Reasoning. The provision regarding confiscation of proceeds of crime in the said provision does not concern the principle of non penal sine lege. The constitutional principle of non penal sine lege applies to the penalties which are imposed by the state. These penalties are to condemn those who are responsible for committing a criminal offense. Therefore, the above-mentioned concept of penalty has to be put into consideration when determining whether certain disadvantage measures bears penal characteristic. It is within the legislator's discretion to decide on the legal measure against offenses in the form of state intervention in people's freedom and property. However, to determine whether the said measure is penal or penal-like, one shall not refer solely to the fact that the measure is stipulated in the criminal code. Neither shall one focus solely on the property or economical disadvantage the measure imposes, nor shall one be constrained by the legal definition of penal wordings set out by the legislator, but one shall rather observe comprehensively on the nature, the purpose, and the effect of the measure, to decide whether it is equivalent to a penalty or penalty-like. If the measure is not, then it does not concern the principle of non penal ley. Viewing the new confiscation scheme comprehensively, confiscation of proceeds of crime, hereinafter the said measure, is not penal, therefore can be distinguished from penalty. First, in terms of the said measure's nature, once an act fulfills the constituent elements and the criminal illegality of a crime, regardless of the offender's culpability, the proceeds derived from such crime shall be confiscated to restore the proprietary status quo ante before the crime was committed. So this is important, so I will read it again. In terms of the said measure's nature, once an act fulfills the constituent elements and the criminal illegality of a crime, regardless of the offender's culpability, the proceeds derived from such crime shall be confiscated to restore the proprietary status quo ante before the crime was committed. That is to say, confiscating the proceeds of crime is not out of the nature of condemning the crime committed by the offender or a third party. In other words, the said measure can be distinguished from a penalty, which is stipulated to punish those who fulfill all three requirements of constituent elements, criminal illegality, and the culpability of a crime. Second, in terms of the subject of the said measure, Article 38(1), paragraph 1 and 2 of the Criminal Code stipulated that, other than the offender, a mana fide third party who obtained proceeds of crime is also subject to confiscation. This is to prevent the offender or the bona fide third party from reinvesting proceeds of crime into other illegal activities. This purpose does not have a penal nature, therefore can be distinguished from a penalty. Third, in terms of the object of the same measure, Article 38(1), paragraph 4 of the Criminal Code stipulates that the proceeds of crime which the state may confiscate include any property derived from or obtained directly or indirectly through the commission of an offense. In other words, a certain amount of the same measure can be deduced by law, and the state can only impose confiscation upon the offender and the mana fide third party within this designated amount. This amount does not regard the severity of the crime, nor is it determined by the degree of culpability of the offender, e.g., out of intentional or negligence. But on the contrary, the sentencing of the penalty is strictly constrained by the principle of non penal ley, the principle of non penal culpa, i.e., the principle of culpability. When it comes to the sentencing of a penalty, the severity of the crime committed and the culpability of the offender shall be put into consideration, whether it regards the sentencing of imprisonment or monetary penalty. Fourth, under the new confiscation scheme, conviction is not required when it comes to confiscation from a defendant who is ruled not guilty. Confiscation from a third party or independent confiscation pronounced on object. On the contrary, a conviction is required when it comes to carrying out the penalty on the offender. Fifth, in terms of execution of a said measure, confiscation of proceeds of crime can be distinguished from monetary penalty. Article 38(1), paragraph 3 of the Criminal Code stipulates that if confiscating the entire or partial proceeds of crime has failed or is inappropriate, the value thereof shall be collected from the offender. That is to say, compulsory collection is the sole substitutive the main means for confiscation in the Criminal Code. In contrast, those who cannot make payment of the fine may commute it to labor service or social work under Article 42, paragraph 1 and 2, Article 42(1), paragraph 1 of the Criminal Code. 6. In terms of subsidiary subsidiarity of the same major in accordance with 38(1), paragraph 5 of the Criminal Code, Article 38(3), paragraph 2 of the Criminal Code, Article 473, paragraph 1 of the Code of Criminal Procedure. If the proceeds of crime are returned to victim legally, the proprietary status quo ante disrupted by the unlawful conduct will thereby be restored. The state shall not confiscate or collect from the offender or third party who have acquired the proceeds. The victim can also file a motion to have the prosecutor return the confiscated items. G. For the above-mentioned reasons, the nature of the said measure can be distinguished distinctively from that of the criminal penalty. 4. The legislative purpose of a new confiscation scheme is to restore proprietary status quo ante, rather than depriving existing properties. When the legislator amended the said provision, they expressed explicitly in their racial legend that they drafted the provision based on the long-standing universal legal principle of crime doesn't pay. The legislators also expressed in the racial legend that to stick to the legal nature of confiscation, which is independent of the legal effect of a penalty or rehabilitative measures. They refer to foreign legislative material, notably Chapter 5 of the United Nations Convention Against Corruption, Chapter 3, Section 1 and 7 of the German Criminal Code, and Chapter 10 of the final draft of the revision of Penal Code of Japan, so that the confiscation is stipulated independently in Chapter 5(1) of the Criminal Code, which is an affirmation that it does not bear the nature of penalty. From this perspective, the legislator amended the said provision to restore the proprietary status quo ante, rather than rectifying crimes and deterring recidivism. Although the Criminal Code adopts the relative gross principle in determining the range of the proceeds of crime, one can hardly deem that the confiscation has the nature of a penalty or penalty-like. The calculation of the range of criminal proceeds based on whether to deduct the cost or not can be divided into two methods, the net principle and the gross principle. The latter can be divided into definite gross principle and the relative gross principle based on whether to deduct the expenses that are not related directly to criminal offense from the gross proceeds of the crime. Consistent judicial practice in Taiwan is to adopt the relative gross principle, which means that if the transaction of the expense deliberately incurred to commit a criminal offense is illegal in itself, e.g. the expenses to purchase narcotics, it shall be deemed neutral and tainted with unlawfulness, consequently not deductible from the gross proceeds of the crime, e.g. the gross amount of the selling narcotics. On the contrary, if the transaction itself is not prohibited by law, e.g. the expenses to perform the contract after winning the bid of the said contract illegally, then the cost of the transaction are neutral and consequently deductible from the gross proceeds of the crime, whereas the unlawfulness only extends to the profit brought by the crime. Furthermore, when drafting the new confiscation scheme, the legislators refer to the provision and the purpose of unjust enrichment in the Civil Code. Under Article 1A(2) of the Civil Code, the recipient of unjust enrichment shall bear a different amount of risk and a diverse range in returning the interest or values determined by whether the recipient knew of the absence of legal ground at the time of reception or not. Per the aforementioned criterion, the legislator weigh the nature of a criminal law and apply the judicial logic of risk allocation to a confiscation of a proceeds of crime, thus burdening the offender and may fight the third party with the risk of losing their unlawful expenses to confiscation. Not to mention that the law does not even protect the parties to recover their expenses in legal transactions, hence a fortiori, the state shall not allow parties to deduct their unlawful expenses from the proceeds of crime. Since the nature of the said provision is to restore the proprietary status quo ante, the offender or the manner fighting third party is not in a more disadvantageous position than they previously were. For this reason, the practice of adopting a relative growth principle in calculating the proceeds of crime cannot be deemed as containing punitive natures. In conclusion, viewing the nature, purpose, and the effect of confiscation of criminal proceeds comprehensively, it does not have the exact nature of a penalty. Hence, the said provision stipulating that the law enforced at the time of judgment shall apply does not violate the principle of non penal sine enshrined in the Constitution. The said provision is a law with force retroactivity effect, which does not constitute a violation of the principle of lex non-retro non-agent, principle of non-retroactivity, and the principle of legitimate expectation. Applying new law on existing constituent elements. Applying new law on existing constituent elements or legal relations that started before the new law is not a retroactive application, nor does it concern the principle of lex retro non-agent, principle of non-retroactivity. Although the said provision led to the application of Article 38(1) of the Criminal Code to criminal proceeds that had happened before the enforcement of the said provision, it is in fact an application to a continuous state of unlawful proprietary status caused by the crime. For this reason, the said provision is a law with only force retroactivity effect, and it does not violate the principle of lex retro non-agent, principle of non-retroactivity. Human life has continuity to it. Therefore, although specific new laws do not have a retroactive effect, their effect on the order of life surrounding the previous law is still unavoidable. Hence, in the case of enforced retroactive legal changes, protection of people's legitimate and reasonable expectation must be put into consideration following the constitutional principle of legitimate expectation. When a conduct fulfills the constituent element and the illegality of the crime, it is prohibited ab initio by the legal order. Any proceeds deriving from it are thus tainted with the unlawfulness, and this unlawfulness shall not be any different just because the said provision was not enacted at the time. Although the said provision did affect the offender and the manner fighting third parties' order of life based on the previous laws, the proceeds of crime were obtained by them through unlawful conduct that disrupted by the status quo. Therefore, their rights on the proceeds of crime are grossly unlawful and defective ab initio. For this reason, the expectation of them to keep the proceeds of crime permanently shall not deserve protection. In conclusion, the said provision when applying to confiscation stipulated in Article 38(1), paragraph 1 and 2 of the criminal law does not violate the principle of lex retro non-agent, principle of non-retroactivity, and the principle of legitimate expectation.